Florida Live starts now.
Well, welcome into Florida Live. Garrett Weimer here, and thanks for joining us on this Thursday afternoon. Welcome if you're joining us on Fox Local Tampa. If you are continuing to watch with us here on Fox Local Orlando, we are listening in on this Anthony Shea bond hearing going on right now, live in an Orange County courtroom. Anthony Shea is charged with first-degree murder with a firearm and tampering with physical evidence in connection with the death of his wife. Now, this happened back in October. He is accused of killing his wife and then staging it to look like a suicide. These are their photos. They worked for the Orange County Sheriff's Office, both of them as well. Today, we've heard a lot of evidence. We've seen some text messages, heard an audio recording that was recovered from Ellie's phone, and now the detective who you see on this stand there is being cross-examined by Anthony Shea's defense attorney. So we will go ahead and continue to listen in to this as this testimony, or cross-examination rather, continues live in Orange County.
That we can look at it and say, haha, you know, that death knell that we look at in a year's worth of investigation and dozens of repositories for evidence and records. How many interviews have you done?
Many.
Dozens and dozens, right? I've got a copy of the witness list. In any of that, anything conclusive that points to him and says, we got you, we know you did it, and here's why?
His DNA is on the trigger.
Of course.
There was gunshot residue discovered inside of his vehicle.
Right. And he was a cop, right?
Not at that time.
He owns guns.
Yes.
Okay. Do you consider that conclusive? That he had gunshot residue on his steering wheel?
Objection. Proper opinion.
Overruled.
I think it's telling. After the death, he's got, there's gunshot residue on his hands and then discovered inside the car.
Okay. So if he is, in fact, and you perceive him to be a focused first-degree murderer, right? He planned it and decided to do it and then did it, right?
Yes.
He didn't plan for her to be sick that day, did he? There's no evidence that supports that, right?
No.
She just called in sick, maybe because of the argument they had the night before. Maybe she really didn't feel well. No evidence to tie that to Mr. Shea, right?
Correct.
And nothing to suggest that he did anything to hasten her death, like what I mentioned earlier, as graphic and inappropriate as that is to say in front of family members who have lost a loved one. He didn't do anything to hasten her death, since the gunshot to the head didn't kill her, right? We know it didn't immediately kill her, right?
Correct.
Any evidence he did anything else to hasten her death?
He delayed reporting.
He delayed reporting how long?
Because if he shot her, he didn't immediately report it.
I apologize. I thought you meant when he got home under the theory that he didn't know, that he didn't shoot her. So, yes, certainly if he shot her, then he waited an hour to call. Why not wait 3 hours, by the way, and just make sure that she expired from lack of care? Any insight?
That would be a question for Anthony Shea.
Mm-hmm. I'm just curious, based upon your investigation, if you can give us any insight from what you say as to why these seeming inconsistencies, maybe, with your theory of intentional murder may have happened.
Objection calls for speculation and improper expert opinion.
Sustained.
In listening to the voice messages that were presented through Ms. Hilly of Ms. Shea, did you afford any significance to it that she had talked about suicide?
Yes, because she follows it up with that she wouldn't do it based on her having 2 children and being wanted to be present for her children.
Of course. Lieutenant Dillon may have had the same thoughts. Would he have had?
Objection calls for speculation.
Sustained.
Do you know, have you been trained at all on what leads people to suicide?
I think that would be different for everybody.
Okay. And I think your evidence, your investigation presented that you testified that Mr. Shea did not want the divorce, correct?
Correct.
Wanted to try and work it out, correct?
Yes.
And didn't want to move out of the house, try and keep the family together, right?
Correct.
Just about done, but I had a question. It was just a curiosity. When you mentioned that the table was flipped, what relevance do you give that somehow he or someone flipped over a table downstairs? Is that relevant in your testimony or just something offhand?
Just as it appeared to be a distraction.
I'm sorry?
It appeared to be maybe a distraction for the other deputies, an outburst where he would flip a table.
A distraction is what you think that was? Could it have been the result of the emotions of going through and watching your wife die?
It could have.
Nothing further. Thanks very much for the time, Your Honor.
Any redirect?
Yes, Your Honor. Detective Gilberti, did you have the assistance?
Cross-examination coming to an end there in the Anthony Shea hearing of the detective. Redirect examination now getting ready to begin. We're going to take a break here on Florida Live, but we'll continue monitoring this hearing. We're going to take a break and we'll be right back, so keep it here on Fox Local. Welcome back into Florida Live. I'm Garrett Weimer, and thanks for joining us on this Thursday afternoon live on Fox Local and on YouTube. It is time now for our Tampa Connection, and for that we go to Fox 13 Tampa Bay news anchor Linda Hurtado. And Linda, good afternoon. We appreciate you joining us.
Oh, no problem, Garrett. Good to see you. We're going to start Tampa with a interesting fuel theft investigation. 10 people actually arrested, and an 11th is wanted after officials say a 6-month investigation uncovered a diesel fuel theft ring. Hillsborough County Sheriff Chad Chronister and Florida's Attorney General gave details on Operation Van Diesel at a news conference in Tampa this morning. So Chronister says this investigation began about 6 months ago when gas stations in the Hillsborough County area reported a discrepancy in fuel on hand. Investigators in Hillsborough County and other parts of the state then noticed a trend in the diesel fuel thefts, and according to Chronister, the group was responsible for about 350 diesel fuel thefts at 70 locations in 13 counties all across Florida, totaling 185,000 gallons valued at over $650,000. Wow. Detectives say the suspects would pull up to a gas pump in a van and fill a makeshift 500-gallon tank, then take the fuel to a large tractor storage facility where they would sell it for $2 per gallon, well below market price.
They would move the piece of metal, whatever they had in the floor, with these makeshift tanks, 500-gallon tanks in these vans, and they would lower their pump into the tank, and within minutes could steal 500 gallons of diesel fuel.
So during the investigation, detectives obtained 103 search warrants and 41 subpoenas, resulting in those 11 arrest warrants. And 10 of the suspects have been arrested. 8 have been extradited back to Hillsborough County. 7 of those suspects are also in the United States illegally, according to law enforcement. The most of them face a list of felony charges, with the most serious being racketeering. So Bean Point is an area that most of the locals that live near Anna Maria Island are familiar with. It's kind of a dangerous area to swim, but now it will officially become a no-swim zone. This area, known as Bean Point, is off of Anna Maria Island, and the city of Anna Maria made the decision following the drowning of a 20-year-old last weekend. Officials say the young man was one of 5 students at an aviation school in Lakeland who were visiting Anna Maria Island when that happened. In August alone, 4 people were rescued off Bean Point. 2 others died from the drowning. Locals have known for years to avoid the area because of dangerous currents, but now officials want to send a really strong message to visitors and tourists to keep them safe.
Because it's the mouth of Tampa Bay, where Tampa Bay feeds into the Gulf, it has a lot of current, whether it's incoming or outgoing. So that can make the conditions dangerous. Even though they don't look dangerous, there can be a lot of current out there.
People don't realize just how dangerous those currents are. So we want people to follow what the signs say, to heed the advice.
The city of Anna Maria Island says they are working with Manatee County now to install permanent signs for a no-swim zone. Signs have been placed from the Fern Beach access to where the Rod and Reel Pier once stood. So this is an unusual story. Usually when someone senses they're about to be scammed, they are. You know that whole if it's too good to be true thing, right? Well, we have a story of an elderly woman who actually did end up collecting some unclaimed funds. 88-year-old Barbara, who lives in Bradenton, says she got countless letters from law firms and private investigators, all offering to help her claim money they say she was owed in exchange for part of the proceeds, right? So we'll help you get your money, you just have to pay us a little fee. Well, Barbara got suspicious, smart lady, and called Bradenton police, and they launched an elder fraud unit last year to handle cases just like this one. So in Barbara's pile of mail, Detective Jim Carula found a letter from the Florida Department of Financial Services telling her that she had $108,000 in unclaimed stock dividends from a job she had worked at decades ago.
It is life-changing. I took action to get it in the bank as soon as possible, and they didn't bat an eye. So I thought, whoa, maybe it is. Maybe it's just the best thing that ever happened to me.
Isn't that always the best when you find unexpected money, right? So she says she's going to put that money towards her nephew's education and also treat her grandchildren. The attorneys and private investigators who reached out to Barbara, they are allowed to reach out to people and help them get unclaimed property and money for a fee. They use Florida Public Records to get that information. So if you would like to find out if you have any unclaimed funds, you go to treasurehunt.gov. And if you do, you don't need anybody to help you collect that money. The website walks you through what you need to do to get your unclaimed cash or property. I got to check that site. You just never know, Garrett.
Yeah, Linda, I am. What do you think I'm going to be doing during the commercial break here?
I hope you wrote that down. That's right.
Absolutely. I get excited if I find a quarter or a $1 bill in an old pants pocket. So I can only imagine what that feeling is to find $108,000 of unclaimed money like that.
I think she's going to have fun spending it, don't you?
I think so. She deserves it, and was smart about reaching out to police about that as well. Well, Fox 13 news anchor Linda Hurtado, we appreciate you joining us for our Tampa Connection.
All right. See you tomorrow, Garrett.
See ya. We're going to take a quick break, and we'll be right back.
Florida Live starts now.
Now, welcome back into Florida Live. They're now showing some body camera video showing police officers on the scene responding and their confrontation and first interactions with Anthony Shea. This is coming from that hearing that is going on right now in Orange County. Let's go ahead and listen in, and viewer discretion is advised here.
The defendant doing at about 3:15.
He's looking at his hands.
What appears to be all over his hands?
Blood.
And is he actually, sort of just moments before this, transferred blood to his head by touching it?
Yes.
And if we go forward to 6 minutes and 10 seconds. We'll publish from the 6:07. What has just happened at about the 6:07 mark?
He's looking at, Anthony Shea is looking at his hands again.
Do we again get a view of his hands covered in blood?
Yes.
Not quite yet. I'm going to publish what's in evidence as states 4. We'll go to 1 minute and 46 seconds. We'll begin publishing at 1 minute and 39 seconds.
Tell me, read. Okay, Shay. Okay, Tony. Here, Tony. No, FD's here. FD's here. Come on. FD's here. FD's here. FD's here. Okay?
What did we just watch for the record?
That's when Sergeant Shelley Pomerleau arrives on scene, enters the bedroom, and Anthony Shea is doing CPR at the time. So she pulls him off so FD can continue CPR.
I want to go to just one more section of this video. We'll go to the 37-minute mark. When the defendant is talking about not getting up there and starting CPR and not stopping, he's referring to his initial entry into the bedroom there?
Yes.
I want to go back to
You may. I've got this one if you need it. No.
what's in evidence as states 9, just one more. Detective Gilberti, is this the a still shot from the video that captures the defendant carrying his daughter over to the neighbors when he's taken a break from the CPR that he's told you he did nonstop from the time he entered that room?
Yes.
Did that child have blood on her?
No, she did not.
How do you know that?
Through the neighbor that he brought her to. He did not observe any blood. Deputies were on scene, did not observe any blood on the child.
Did you talk to 2 other individuals who were present in that home when the child was brought to the home?
Yes.
And who were those people?
They're the Hall family, so Henrietta Halls, Frank Halls, and their daughter.
Were these individuals with the children for an extended period of time after the defendant had dropped the 2-year-old and the 7-year-old off?
Yes, so the children remained in the neighbor's residence during the investigation. And there was a deputy with them during that time.
Any of those individuals observe any blood on either the 2-year-old or the 7-year-old?
No.
Is there a body cam that captured the appearance of those children inside the home?
Yes, the neighbor's home.
Inside the neighbor's home?
Yes.
And is there any blood or anything that even looks like blood on that 2-year-old that was in the defendant's arms as he ran out of the residence?
No.
I have no further questions of this witness.
I do, if I may.
I don't usually allow recross, otherwise there's no, is it
Well, no,
fully new area?
Fully understand. I don't consider this recross. I consider it cross because he went into so many areas that were not covered in his direct.
All right, I will give you little leeway, but very little.
Well, no, only that which he,
All the new stuff.
yeah.
Okay.
Good afternoon now. Regarding the last, so you consider it to be an inconsistent statement, or maybe as much as a lie, when he said, I did CPR and never stopped, when we now know he did. Is that accurate?
I think there would be more presence of blood, with all the blood that he had on his hands and his shirt and his arms.
We're going to get to that.
Okay.
But it was brought up as though, and you testified that he said he performed CPR and never stopped, right?
That was his.
But we know he did, right? And would you go as far as to state that we know that Mr. Shea knows he has a Nest Cam
Yes,
that would capture him taking the kids over there?
yes,
And that those witnesses, those neighbors would be talked to and they would say, oh, yes, he brought the children over here.
yes,
And that would document that he must have stopped CPR for a couple of minutes to get the kids out of the way.
yes.
Okay. Any real significance with that inconsistent statement where he said, I never stopped CPR, when it's obvious he did for a few minutes? You could give that any investigative significance at all?
No,
Okay. Similarly, there wasn't blood on the children, correct?
correct.
Of course, there wouldn't be any blood from mom on the children. It would only be what we know to be transfer blood, correct?
Correct.
And we know that when he went back to the house and continued the CPR, as we saw him on the video, that he had blood on his hands.
Correct.
Any evidence whatsoever, anything that you could show us that suggests that he didn't just get the blood on his hands when he went back upstairs to deal with Miss Shea after getting the kids out of the way?
The significance would be the amount of blood that he had on his hands and his arms and his shirt during the body cam when he was talking to deputies. You would expect that there would be blood on the children's clothing,
You would think,
and it was absent.
particularly if he had that much blood on him when he was carrying the child.
Correct.
And if he didn't have that much blood on him because the blood got on him afterwards, maybe because, I don't know, the CPR was working and she was still breathing and therefore bleeding even more. Because that's what happened when a body actually respirates, you bleed out more, right? You know that, don't you?
Yes.
Okay. So if the CPR is working, she's going to be, unfortunately, and as graphic as it sounds, she's going to be pumping more blood through that wound, right?
Yes.
Okay. And that could have been where the blood came on Mr. Shea that we now know full well is all over the place on him because it shows up in all the body cams.
Yes.
There's nothing, I'm sorry. Go ahead.
Okay.
Right? Isn't that a reasonable explanation as to how it happened?
I believe he didn't start CPR until he returned back to the house after drunk.
It's your belief that he just let her continue to die, did whatever, looked around, and then took the kids out, came back, and it was only at that moment that he decided to start CPR, maybe to make himself look with great theater to the deputies he knew were showing up.
Correct.
That's your theory. Anything to support that at all? Just one sliver of actual evidence, forensic evidence, video, audio, anything that could tell us that your supposition that that's what he did should carry any weight whatsoever.
There's a lack of blood on the children's clothing.
We got to that, and I suggested that may be an explanation for that. Now we're talking about the fact that you just made a suggestion that he didn't even start CPR until he got the kids out, and that he's continuing to lie through his teeth, to you, to everybody else, and he only came back and did it as theater. That's your belief, right?
Yes.
Okay. Any evidence to support that, or just your own? You think he did it? You think he killed her?
Just based on the investigation.
But I'm asking for evidence. Do you have any?
No.
re-cross-examination of that detective going on right now. We're going to go ahead and take a quick break here on Florida Live. I do want to just let you know there were portions of that body camera video that we just had to cover. It was showing graphic body camera video there. We're going to take a break. We'll keep monitoring what's happening in this hearing, but we'll be right back after this. Welcome back into Florida Live. Garrett Weimer here on this Thursday afternoon. I want to get you back inside this Orange County courtroom where the attorneys are now making their kind of closing arguments in this bond hearing. We know the defense attorney is saying that there are several reasons that he believes Anthony Shea should be out on bond. Let's go ahead and listen back in as the defense decided not to call any more witnesses. They just cross-examined the detective who the prosecution put on the stand. But we're now hearing these final arguments here ahead of a judge's decision. So let's go ahead and listen back in.
Then so be it. Here's what we have in the state's best case to presume that the presumption is great. Maybe he didn't have a lot of blood when he took the daughters out of the house. Maybe he waited. Well, my counter, you've heard it through the cross-examination. If you're talking about a true, absolute first-degree murderer, why not wait 3 hours to come home? Why not put your hand, why not finish your job if that's what you're doing? I know it sounds grotesque to say it that way, but that is what the state is saying. So when we look at this evidence in the cold light of day and say, what has the state proven to show you that he should be detained and his liberty taken away before any jury says it should be, because the proof is so evident and the presumption is great. Where's the confession? Where's the forensic evidence? Where is the support that this wasn't a suicide? Because I would suggest to you that in a circumstantial evidence case, such as this seems to be, then the hypothesis of innocence has to be disproven by the state. I know we're not a jury, but nonetheless, they have to disprove what may have happened. What may have happened is just like, unfortunately, happens literally thousands of times a day, that people commit suicide because of what they're going through. Now, that's not for today to determine necessarily, but you do have to determine whether or not it is so evident that he did it, that his liberty should be taken away from him today. They should not be available to me to prepare a defense in this case. And he should sit in the Orange County Jail until this is done. I don't think the state has proven the case. Where is the evidence that you can sit back and say, we got you? Where is the firearm evidence? Where is the video of the bank robbery? Where you sit back and go, O'Mara, he's not getting out because we can tell he did it. I would suggest to you that we certainly can't tell he did it to the standard before us today, which is the state's burden, and he needs to be out. The state has an extraordinarily and limited circumstantial evidence case that carries with it nothing other than supposition. The last question answered was probably the best. Give me some evidence. Do you have any evidence to support what you're suggesting happened? Well, there was 52 minutes of silence. Well, the door was locked. The door wasn't locked. Did we hear the door being broken into? The door was locked for the daughters, maybe. And then dad or mom, I have no idea, unlocked it. But we're hearing this, and we're laying this on top. And he did this, and he did that, and he took off for a day. What does that have to do with first-degree murder? That they were having marital dispute. If we take away the periphery, if we take away the innuendo and the supposition, and just really look at the facts as presented by the state, and they've done a good job of cobbling it together with 50 or 60 subpoenas to third parties, by the way, none of which has supported anything of their case. The Cellbrite. We got a lot of evidence from Cellbrite. We've heard what resulted in that. Other than that, bank statements, whatever. They're going to, I guess, make some big way that he was getting ready to leave the country or something like that because he has passport in his bill bag. There's no evidence presented as to what trips they had planned, money, where that was going, where it came from. They did the bank statements. Where's the evidence of that $3,000 and what it was taken out for? Any evidence of that whatsoever? It's supposition. It is not the burden that they have to carry. You should give him a reasonable bond based on his circumstances and let him out with whatever conditions you want, because it is an extraordinarily serious case. And let him out so you can help him.
Mr. Wiggins?
Yes, Your Honor. Ellie Shea was not suicidal, and that evidence is uncontroverted. The facts before the court, which include the summaries of interviews that were conducted with individuals from all parts of her life, established that there is no support for the idea that she was in a mind state where she would have ever taken her life. And the court doesn't have to just rely on their words for it. We have a very unique situation where a little more than a month before this occurs, as a result of a suicide that happened within the agency, the court heard with its own ears Ellie say that she would never leave her girls, that she would never abandon them, she would never take the easy way out. And she went a step further. She reflected on the fact that this fellow deputy had taken his own life in his own home and how damaging that would have been to the family, and suggested that at least leave the home. And so there's sort of these two components of this audio recording that is so powerful in refuting this idea that Ellie would have taken her life, which include her saying that to do it in your own home is just unfathomable to her, and it was unfathomable to even consider it because she needed to be there for her children. Ellie Shea did not kill herself. What the timeline establishes with the homicide case timeline that the court has, and both through this exhibit, which is an evidence, and the testimony surrounding the exhibit, and some of that, or a good portion of that, comes from the defendant because he talks about what was going on between the two of them the night before. that there was some extraordinary argument between the two of them, and they were up till 3 in the morning, apparently, according to the defendant, and you heard that the defendant is out in his car at 3 in the morning. The next morning, she calls out of work. She doesn't go into work. And at 12:46:41, she searches on her phone, "I am a cop and my husband sexually assaulted me." She is dead within 45 minutes of that search. How do we know that she was dead within 45 minutes of that search? That audio recording is direct evidence of this defendant's guilt. It's direct evidence of the fact that Ellie did not commit suicide. The defendant, in his version of events, which is discussed in the second interview, when he's asked about sort of immediately before he left the residence, he's asked, did you go in the room to say goodbye to your wife? And he says that one of the little ones went up to the door, tried to get in, and was locked, and we left. I never went inside. And then when he comes home, he says the door is open. He walks through an open door and finds Ellie. So the defendant does not put himself in the room during the period of time that the recording has begun. Because what occurs is the court can understand through both the recording and the digital forensic extraction is this defendant sends the Brussels sprouts text to himself, and within a second or so of that text, the recording begins. And what do you hear at the start of the recording is you hear a child in the distance. You hear a child at the door. And what you hear is you hear the defendant close to the phone, and then you hear him walk away from the phone. You hear the sound of the door opening. You hear him addressing the child, and then you hear him closing the door. So the defendant is there with the phone the moment the recording starts. That is inescapable. And this recording, both the enhanced and unenhanced version, tells that story clearly. And what the court will hear when it listens to it is what you don't hear until the defendant re-enters the room. Because Ellie has to be alive for this defendant's story to work. She has to commit suicide in the room after he departs. We don't hear a gunshot, but what you did hear before he left is the smallest of sounds within that room. The shuffling of sheets and footsteps. You don't hear a gunshot. You certainly don't hear Ellie moving around or doing anything within the room. But I shouldn't focus on that. The gun is never fired. You then hear that while the defendant is out at Publix, he schedules a counseling appointment. He has killed Lloyd Shea, and his cover-up is underway. That cover-up is the alibi that he's creating through this Brussels sprouts trip. What is interesting, and the court sees in the forensic or the timeline, is that at 12:22, this defendant made a note about getting Brussels sprouts earlier in the day. 12:22, he makes his own note about getting Brussels sprouts. And lo and behold, the text that he is purported to be sent by Ellie is a request to go get Brussels sprouts. So he's constructed this alibi. He hasn't thought it all through. Clearly, that was a mistake in the construction. But he schedules an appointment for a woman who is dead in the home. The lengths that he was willing to go to cover this up. He involves his children. He takes his children out of the house as part of this alibi that he is crafting. And then he comes home and he sends the texts about, again, to continue to set up this alibi upon his return. Those text messages are in Detective Gilberti's report. It's also in the CSI photos, and you see how he is crafting his excuse in those texts. And then he goes upstairs. The court is able to hear with its own ears this defendant enter the room. He is in the room for 51 seconds, completely silent. We know that he receives a cell phone ping, you hear his phone ping, and you hear that he turns his light on at some point. Not a word, not a sound in reaction to what is before him. And then you hear like a whimper that builds. And it's not until 911 connects that all of a sudden he's hysterical. It's inescapable. It is direct evidence of his guilt. The idea that he would come in and see Ellie and appreciate her condition such that he's dialing 911 but stand mute next to her, it's because he did it, of course. So then what does he do in that call? The court hears him drag Ellie off the bed. You hear that sound of him dragging off the bed. We have the CSI photos that show how bloody the bed was. The bed was a bloody mess already. The headboard is soaked with blood. The bed is soaked with blood. The sheets are soaked with blood. Ellie is soaked with blood. She's been shot in the side of the head. He drags her off the bed, and then he says, "I am performing CPR." He is not. He is not performing CPR. He is on his phone with it to his ear, and he is standing over her. The idea that somehow it was only after he returned that there would have been blood such that he would have transferred it to his children obviously defies all common sense and reason. The bed was soaked with blood. She was soaked with blood. And so what happens is once again, a child comes to the door. Likely the same child who spooked him when he was sending the text, which caused the inadvertent recording to start. And that causes him to go and scoop up Rocky. And this is where it all falls apart for him. Because Rocky has to have blood on her. She has to have blood on her for him to have been performing CPR. Because if she doesn't, he has been standing there pretending to perform CPR. So he brings her to the house with no blood and then goes back. And we pointed out when the phone switched to speaker because that is when he actually starts CPR. That is when he starts CPR because now the phone has been set aside and he is using both hands to perform CPR. And so the court can pinpoint the moment where he actually starts CPR. He switches over to speakerphone and he doesn't have the phone to his ear and he begins. And he continues until law enforcement gets to the scene, and then he has to be pulled off. He refuses to stop CPR, although he refused to start. The defendant has been charged with tampering with evidence, in this case, in addition to the first-degree murder, because the defendant, certainly being a law enforcement officer, knew exactly how important it was for that scene to be preserved, and if it had been preserved, what the investigation could have done to reconstruct his story. And so he is part of this cover-up. He very purposefully moves her from the bed, changes the scene, repositions the gun to destroy the state and the investigation's ability to perform any sort of comprehensive reconstruction of the murder. That is a consideration both for the defendant's consciousness of guilt, but also for the court's consideration for whether it chooses to exercise its discretion if the state met its burden. This defendant, his life was falling apart. He had been fired or he had to leave the agency under disgrace. His wife was divorcing him. He was being forced out of the house. He had lost his job under circumstances that were preventing him from finding any other work. He was concerned about how he was going to support himself. In 45 minutes before she is killed, she is searching for what to do when she has been raped by her husband. So this defendant had a motive. Your Honor, there are no conditions of release that can reasonably protect the community from physical harm to persons. I think the nature of the crime itself speaks to the danger this defendant presents to the community. He murdered his own wife. The state offered the evidence concerning this earlier episode where he sort of disappears, because I think it speaks to the risk of him being at liberty, that he sort of disappeared from his family, his wife and his children at that time. There was a concern about him committing suicide during this period of time, and so the state offered that evidence to provide the court with additional basis for why it should not choose to exercise its discretion. That episode, I think, goes to that. Additionally, under Arthur, the court should consider whether release could assure the presence of the accused at trial. There is no bond amount that would ensure this defendant appears for trial. He is looking at a life sentence, and he risks nothing from fleeing from the court's jurisdiction. Additionally, the court saw in evidence that at the time of the arrest, which was 4 days after, this defendant had a backpack with $3,000 in cash, a passport, medications, and his wallet, and a laptop. That is completely consistent with an individual who wants to be prepared to leave with all items necessary to facilitate his release. He had his birth certificate in that bag. That was a bag that indicated this defendant's willingness to potentially flee the jurisdiction. I think it speaks to the risk that he presents. Additionally, Your Honor, there is no bond that could assure the integrity of the judicial process. I think that the defendant's conduct subsequent to the murder, the lengths with which he went to cover this murder up, to construct his alibi by essentially sort of enlisting his young children and constructing this alibi with this trip to Publix, the access that he would have to witnesses, and the sophistication that he would have to understand on how to influence this investigation to entertain, giving him liberty such that he could somehow damage the integrity of this proceeding. And so for all of those reasons, I would ask the court to find that the state has met its burden, that the evidence in this case is overwhelming and points to only one conclusion, is that this defendant murdered her. He did so with premeditation, and he should be held to no bond.
Mr. O'Mara, any rebuttal?
Just that the state's theory is a story. It's just not supported by the evidence well enough to meet their burden. Suicide is an act of insanity. There's nobody in the annals of history who has done suicide as a rational thought process. It happens because you don't think about it. And you don't do what's rational. And yes, you might say to somebody else, how dare that person do it, but we would be a suicide-less society if we actually thought through our actions. And unfortunately, there's certainly compelling evidence that that's exactly what happened here, and the forensic evidence does not support the state's met their burden. It is sad that it happened this way, but the state's got to convince you by quite a high standard to maintain a private life liberty. I would suggest, without repeating myself, he simply did not, and that he is entitled to bond under law.
There's one point I forgot to make in terms of my argument, and also in terms of the amount. I didn't have, if I could just speak to that.
You may.
Just the point that I forgot to make in the argument section is that, and the court, I'm sure, has sort of listened to the testimony and saw the exhibit, but this defendant's DNA is the only DNA on that trigger. It is a single source, complete profile, which I think, considering the shared nature of this gun and the amount of blood that was present on the scene, the absence of Ellie Shea's DNA on the trigger of the firearm used to kill her in a single source complete profile, the present being the defendant, is powerful direct evidence of his guilt. I forgot to mention that. Last, Your Honor, as it relates to the consideration of the bond amount, the defense has made a proffer concerning his means to pay. There is evidence within the I believe it's Sergeant Palmer Lou's body-worn camera recording. The defendant makes reference to a retirement account that was in the amount of $600,000. It's been proffered to you that he also has a mortgage on the residence. I would submit to the court that his access to funds is far greater than, I think, maybe what was initially proffered, or it's great. I would say greater than what was proffered to the court. And the court, if it's considering a bond, should consider a bond commensurate with his access to capital and commensurate to the risk that he poses in terms of flight, which is extraordinary, and impose a bond in excess of $1 million.
Thank you. Because I need to review Exhibit 14 that was admitted this afternoon, I will render a written ruling, hopefully sometime tomorrow. If not tomorrow, Monday.
Thank you for your time, Your Honor.
All right, thank you. Everyone have a good day. And I am going to keep these.
See Anthony Shea there being remanded into custody after an hours-long bond hearing in Orange County that is wrapping up. You heard the judge there saying she does plan to issue a written ruling likely tomorrow. If not tomorrow, then on a Monday, so still awaiting a decision on that. But lots of argument, lots of testimony from the detective in that case. Some cross-examination, some back and forth during the closing arguments there as well as to why they believe Shea should be out or why he should be held behind bars with no bond. We are just about out of time here on Florida Live. Want to let you know something that we are standing by for here on Fox Local, though. Waiting for Pam Bondi, the Attorney General of the United States, expected to speak this afternoon with a group of U.S. attorneys. You see it, the U.S. Attorney for the Middle District of Florida office in Tampa there. Expecting her to talk about, to announce some significant enforcement efforts to combat human trafficking and also combating smuggling along the U.S. border. So we anticipate that announcement here very shortly, and we'll bring that to you here on Fox Local. But we are out of time for Florida Live. We appreciate you joining us. We'll be back here at tomorrow at 2 o'clock with more Florida Live here on Fox Local and on YouTube. Welcome into Fox 35 News Plus. I'm Garrett Weimer, and thanks for joining us. And it looks like we just lost our feed there. Give me 1 second. I do still have it that I can pull it up here. This is a live look inside the office of the U.S. Attorney for the Middle District of Florida in Tampa, where we expect an announcement here shortly from Attorney General Pam Bondi, who is in Tampa, getting ready to announce some recent enforcement actions by the Joint Task Force Alpha. They are combating what's labeled as transnational criminal organizations involved in human smuggling. We expect there to be a number of U.S. attorneys as well joining her, and partners from the Department of Homeland Security as well that are going to be there for this announcement in Tampa any minute now. We will bring that to you live as soon as it begins. It has been a busy day here on Fox Local. A lot of things to cover, and some things that we haven't even had the chance to get to yet. We've been keeping a close eye on that Anthony Shea bond hearing throughout the day that has wrapped up for the day. We expect a ruling on that from the judge, a written ruling tomorrow on that. So no decision from the judge on that today. The city of South Miami is one of the localities that has been vocal in fighting against these 287G agreements, which are the agreements between local police, local law enforcement, local sheriff's offices, and ICE, the federal officials, when it comes to immigration enforcement, basically allowing them to do some immigration enforcement actions. South Miami has pushed back on that, and today the mayor of the city of South Miami held a news conference to urge other Florida cities to cancel their 287G agreements. That's because they say that in court, the state argued that only counties and sheriffs need to sign those 287G agreements with ICE. This has been a point of contention and a question about this, and one reason that the city of South Miami kind of pushed back on this to begin with. And so we heard from Mayor Javier Fernandez earlier today in a news conference, and here is what he said, encouraging other cities to cancel their 287G agreements.
It's no secret that our city to date is the only city to formally challenge the governor's position, the state attorney general's position, with respect to the existence of a mandate for cities that do not operate jails to sign a 287G agreement. I was humbled to hear and felt very validated to hear the state's own lawyers admit on the record during a hearing on the state's motion to dismiss our lawsuit that in fact no mandate exists. It validates what we have long known to be the law, because in black and white, the law does not include a mandate. And the legislative history on this item going into the last special session validates our position and confirms the fact that what we have all been experiencing in recent months is a series of threats being lobbied at local jurisdictions to try to force us to adopt a position that is aspirational on the part of the governor to have the law read as he would like it to read, to have it read in a way that the legislature did not acquiesce to his request in the past legislative session. So we felt extremely validated. We were encouraged by their own lawyers' remarks that we will prevail not only in the motion, but ultimately get the clarification that we thought was the correct reading of the law when this declaratory action is settled here, hopefully in the coming weeks, that there is no mandate and that cities are free to not sign these very onerous and unnecessary agreements. And my reason for joining today is to frankly highlight for my fellow mayors and local cities the fact that they are under no obligation to sign these agreements. Again, in the words of the lawyers of the very two elected officials who are trying to force us to do this across the state under significant duress, and that their resistance to signing is validated, not just because of the political merits, the moral merits of not joining in this effort to needlessly target the most vulnerable in our community, but because it's what the law says. And ultimately, we are and should be a nation of laws, of rules, and not the political aspirations of one individual or two individuals should drive outcomes across our society. And so I'm encouraged by the statements of counsel for the state on August 21st. We look forward to hopefully a final and positive disposition of this matter. But I want to encourage my colleagues at the local level to hold steady, to await an outcome on this matter, and hopefully in the future be able to act free of any duress and come to a decision as to whether or not they should participate in these efforts of their own accord without coercion.
I want to thank Mayor Fernandez, as well as the city of South Miami, for their leadership and public display of courage in this matter. I agree certainly that we have a moral responsibility to push back on these agreements and state overreach. Local elected officials are being threatened for even questioning these agreements and whether or not it is legally required that they do. And we know now that the state itself has admitted that it is not a legal requirement that all municipalities enter into these agreements. That's a game changer. I'm optimistic about what that means for our cities and personally for the city of Tallahassee. We have taken, unfortunately, our city manager and police chief entered into the agreement. But we are exploring our options if we want to exit the agreement, which is certainly the way that I feel. Local governments, but at the end of the day, local governments should never be bullied into making decisions that are harmful to their residents and constituents. We have a duty to stand up. And I want to encourage other cities as well that if you are wondering what your options are, that this is a green light for you to step back and reevaluate having entered into these agreements or whether you need to.
So on August 21st, the state of Florida made their position on whether cities are required to enter 287G agreements clear. They said, the state does not interpret Chapter 908 to require every municipality to enter into a 287G agreement. South Miami, the city, is not violating Chapter 908 or even coming close to violating Chapter 908. Later, they stated, again, trying to clarify our view, we do not believe that every municipality must enter a 287G agreement. These are direct quotes from the DeSantis administration and a major shift from the previous stance they had claimed, basically claiming all cities were required to sign or face threats as high as removal from office. These admissions should provide relief to those cities that have not already signed an agreement. Cities who have been under extreme pressure, unwarranted pressure, unlawful pressure to do so. And it should prompt every city that signed under duress to chart their paths out of these entanglements. These entanglements with ICE not only bring the threat of litigation, liability, the inability to insure municipalities, and the erosion of trust in institutions, but we're quickly seeing how they are the basis for mounting and new responsibilities thrown on them by ICE. It is completely concerning that not only are once folks have signed onto these, that they have